You've reached FIT TV. Stick around, we'll be right back. Missing in the Bill of Rights is the right to parent your own children. Shouldn't that be a fundamental right? Did you ever think that in your life that someone could strip you of that right? As early as we can remember, we all want to be parents someday. But is that dream realistic? On FIT TV today, these constitutional and other moral perspectives will be answered by my expert guest of 23 years on constitutional subjects, Leon Kozoil. Welcome.
Pleasure to be here, Chris.
You know, Leon, what I'd like to ask you is what our fundamental cause is in this program is that we live in a divorce culture. And how do you adjudicate a relationship? I want to ask that open question to you. Does that sound like a reasonable thing to do, adjudicating a relationship?
I don't think that courts themselves are inherently competent to adjudicate relationships, as you state. Relationships, particularly parent-child relationships, are very fluid. And they change with each passing minute. There are constant, unpredictable variables that occur. And courts are programmed differently. They're programmed by a record, a very, in my view, archaic system. And they're not really able to govern the parent-child relationship. They are able to govern a lot of things in society that the people commit to their care and custody. Children is not something that the people as a whole committed to the care and custody of the government. Instead, the government has seized that without any constitutional authority and led the public to believe that in fact it does have this power to essentially control, regulate our children. So you really can't adjudicate it in the sense of what a good parent-child relationship is or should be. Instead, if you look at the 2006 Matrimonial Commission report, for example, to the Chief Justice, in it, one of the points that was made by Justice Sandra Miller.
I spoke at that hearing.
One of the points that she said is that inherent in our problems is that we try to shoehorn cases into this oppositional framework, cases that are incongruent. You can't get a more incongruent subject matter for litigation than parent-child relationships. And when they shoehorn them into this litigious environment where you are, by nature, by definition, litigation is an oppositional framework. You can't escape that. It's what lawyers do. It's what they're trained to do. In some respects, you can't blame them for what they do. But when we shoehorn parent-child relationships into that environment, you are destroying the family and everything that we know, this inherent right that goes back from a time immemorial, the beginning of civilization.
How do you figure that that lasted so long, that the state thought in its infinite wisdom that it could step into that natural sociological environment of family, the institution of family, as you expressed, molding on its own? How did you think the state could come up with a plan to intercept and develop on its own some power base?
Well, it really was more or less by accident. Back in 1925, in the case of Finlay versus Finlay, the Chief Justice Benjamin Cardozo, which is, the lawyers really look up to him as one of the great legal icons of his day. And he essentially articulated this parents-patriarch doctrine, the notion that the government is the father of its people. It has ancient derivations. You know, the king is the sovereign over all people. And in its day, in 1925, let's look at the way the environment was. We didn't have a lot of divorces. They were quite frowned upon. And so it was not a big deal for the state to say, whenever you have a separated parenting environment, the state has an automatic interest in this. The children are, per se, in danger because they don't have both mom and dad living in the traditional framework of a home environment. And so the state must step in. Well, and then in its day, it didn't affect a whole lot of people. So people really did, it wasn't on anyone's radar screen. But as time went on, and particularly in the last few decades, you see what has occurred in terms of our moral structure, in terms of our TV influence. And so now we are talking about not just a 5% or minuscule minority of the parenting population. Today we are talking about the majority. Mainstream folks are now in that category that the judge was trying to address at its time. And so now the state is simply acclimated and become a super parent, as I say. And they're ill-equipped to be super. They don't have the resources. They don't have the hands-on experience. They simply cannot physically undertake the literally millions of cases that are coming before our courts today.
Sure, as you say, it's an adversarial process, and now all of a sudden you're going to change that and say, oh, well, we have this psychological issue with your family, so we're going to ask you to hire a forensic evaluator of some kind to step back in and now help us with this determination.
Exactly. What you have, Chris, is a clash occurring, in a modern-day clash. You have this expansive power that the state has seized over our children, which allows them to get into every aspect of our private lives, whether it be through financial inquisitions or telling you how to raise your own children, which they cannot do. There is no utopian parenting philosophy out there, but there's a lot of money in this. It's a multi-billion-dollar industry we're up against. We as parents, and all of us, are in some fashion directly or indirectly involved. But at the same time, what's happening is the Constitution is saying, well, we have a government of limited powers. We delegate our powers, or we limit them to the state. We don't allow them to seize powers as they're doing, and if they do, it's our duty as a citizenry to step up to the plate and say, hey, you've seized too much power. These checks and balances, lawsuits are checks and balances, you know, separations of powers. There are a lot of ways that we go about doing that. The Constitution, although it's not expressly written, but it has always been the rule of law that the only time a state has a right to interfere with parent-child relations if the state has itself proven that either a parent has neglected or abused the child has somehow been harmed.
And that's something I believe that's fairly recent, am I correct? Because there is nothing, I think, inherent in the Constitution originally. Am I correct?
That's correct.
Oh, okay. So
no, that's correct, Chris. There's nothing in the Constitution that says that there is a parenting right out there. But you have to keep in mind how the Constitution came about. The framers of our Constitution in their day were looking at the fringe rights, ones that weren't expressly granted, whether through the Magna Carta or through common law, recognized rights. So free press, for example, free religion was being threatened. We had at that time, of course, one Church of England. And so they saw at the time a need to put free religion, free press, free speech, free association, as it became about, into the First Amendment and other amendments, the Bill of Rights, as we call them today. Parenting right was not among those amendments, and why? Could you imagine somebody in the Constitutional Convention, you know, back in the 1780s, standing up and say, well, folks, I think we ought to recognize parenting rights because, you know, that's a fundamental right we all need to put in this Bill of Rights. That person would have been laughed out of the convention because back in that day, nobody would even imagine that the parent-child relationship was anything but a fundamental right.
And I'm still having trouble with that today.
Right. They purposely kept it out of the Constitution because it would be ludicrous to suggest we need to put that in writing. But over time, that right has become eroded, and principally by who? State, local, governmental entities.
Sociologically speaking, institutions rarely are traversed into the government agency aspect, and family has always been the strongest and largest institution. I didn't see any connection to why that should have happened at any given point in time. But going further into the Bill of Rights, is there anything in the Bill of Rights? Is there anything related to the parent or the ability of a parent to parent?
Sure. If you look at the whole spectrum of rights, whether they're express rights or implicit rights, they involve the parent-child relationship. But, you know, think of free speech. How do you raise your children? We engage them in public interest items, whether we teach them how to the Pledge of Allegiance or our nation's history. We parents are, in essence, exercising our free speech rights when we try to perhaps have a different viewpoint about history than the teacher, for example, might. That's an expression of a right that is definitely expressed, and it's in our Bill of Rights. Free religion. Parents obviously take their children to various places of worship. And in the process, when they do, they're exercising a right. When you remove children from the care of their parents, you are violating that full spectrum of rights. And how are children ever going to grow properly, especially under our form of government, if parents aren't there to teach them these rights, or at least engage in the activities, whether it be simply watching a movie or expressing a point? You're not in your mind thinking, well, geez, I'm out here exercising my rights under the Constitution. As a parent, you are. And as a child, you have a right to receive these expressions.
Well, as you said earlier on, there's no plan of action that causes a parent to have an absolute in determining what their family will do and how to manage that family's behavior going forward. So the idea that somebody else could do it for you, it offends me.
Rightfully so. I mean, there's no absolute right, obviously, in parents. We all live in a society where we give up to some degree some of those rights for us to function. On the other hand, if there is such a right, if there's something that is more, if anything is more fundamental, it's the parent-child relationship. That's where we all got started, from birth. And the United States Supreme Court has called it the oldest liberty interest protected by our Constitution, in a long line of precedent. And like I say, that long line of precedent is coming in, it's clashing with the state's abuse of power. This idea that we have such a power, and all we have to do is this declaration that we are looking out for the best interests of your children and mine. And once you make that declaration, it's off to the races. You have a power that's unlimited, unrestrained, yet it clashes with the Constitution and what the Supreme Court is saying. What we haven't had yet, folks, is the Supreme Court and the states coming together in a Supreme Court ruling. That's what I've been doing, the fast track to the United States Supreme Court, because we need to reconcile this clash. The Supreme Court is kind of seeing what the state's doing, but kind of stepping back through these abstention and other doctrines. And the state is saying, hey, you know, they haven't restrained us yet, so let's just keep on going. And who is suffering in the end? Children.
Family.
Parents, families. Families most importantly. You know, I got calls from people saying, well, what about grandparent rights and an uncle and aunt calls? Well, wait a minute. You're all part of the extended family. So when we talk about parent-child relationships, which is at the core, everybody's affected. So it is a much greater issue than just what they're leading us to believe.
Obviously, this is a cash cow that's developed. This clash that you're speaking about, wouldn't the economic fallout be evident at some point? You're going to face the reality that you'll have to dominate a financial issue.
No
I mean,
question.
in your attempt to go at this constitutionally.
No question. The idea of taking on a multi-billion-dollar industry, I have the resources, I have the intellectual ability, the experience to do this, but it takes an immense amount of resources to push this through. What I'm trying to do is easily in the hundreds of thousands, if not millions of dollars, all of what I've been doing, all the different test cases and everything that I have now committed, including sacrificing my own career, and, you know, toward this cause, because that's how much I believe in it, how much I believe the very founding, not only the founding principles of our nation, but our nation itself.
Sure.
Because we're dragging so many people into these family courts, okay? We have almost 300,000 lawyers just in California alone. These people are out there looking for work, and as you know, in any village that can't support one lawyer can always support two, because once you get the controversy started, we're off to the races in terms of getting money from people. Families are dragged into these courts. All the employers that are being, you know, asked to garnish wages, all on behalf of the state. All of this is combining.
All in this adversarial place.
All the adversarial controversies, dragging people in, subpoenaing everybody, documentary production, the law enforcement end of it.
Motion for this, motion for that.
Absolutely. What you have then is a vast percentage, and a growing one. It's a giant, it's an albatross, segment of our population which is being drawn into these courts. And so when they're here, waiting for their case to be called, sometimes they're waiting days before they actually called up to a witness stand. I know, I've been there. While this is happening, who's in the workplaces? Who's out watching the streets for law enforcement activities? Who's out inventing things, which our nation was always so great for? Well, guess what? They're not at work. And so those jobs are going to China, places like that. And so our productivity of the nation is being impaired by all of this.
And we're forcing the woman out to work, which is when you already have the man biologically more able and more not able, wanting biologically to work. And now the female's out of the house, who's watching the kids? It's all self-driven in a lot of ways. We worry about that at FIT-TV. We often talk about that. What I'd like to ask you about is, what do we do when people say, you know, I just want to protect my rights when divorce is imminent? What do they say? What do they do? I mean, what else can they do? I just want to protect my rights. Do they in fact have rights that they have to worry about? Is a pro se activity possible? Or their ability to move outside of the court? What's the chances and the likelihood of that happening?
Well, when they go into court, the most important question they have to ask themselves, and it's inherent when they go in there, is this parent-child relationship. You know, they have to recognize that the state is their enemy. The judge, the parties that are in that court, somebody's going to lose a child here, okay? They call it custody.
Yeah.
And so immediately everybody goes in there with a trepidation, rightfully so, that they're out to harm me, okay? And in fact they are, because this custodial institution of child rearing, this is what I call, for analytical purposes, it makes it a lot easier to understand what I'm trying to attack. If you take a look at that assembly of laws and processes, and many of them unwritten, okay, and bring them together, we have an institution. We have institutionalized parenting. The state has literally taken over the parenting function. We have socialized our country.
Sure.
We've done it through the back door.
And the more laws that get applied, the harder it is to traverse common sense.
Absolutely. Every time something that's on the fringe occurs, they throw a law at it and affects the rest of us mainstream folks in ways that the courts themselves can't make sense out of.
No, of course.
And so what ends up happening is the state then becomes the functional parent, and they're not able to do it. They can only look through a prism of what's narrowly occurring at a given time. So when people go into court, they have to recognize this, because before they even know it, they're not on the outside. They are now on the outside looking in. If you're a non-custodial parent, and many men in particular, they are non-custodial parents at the time they were born, not when their children were born, at the time when they were born, because they were born physically under New York law, absolutely incapable of becoming a custodial parent. Take the example, one of my test cases, the father separating from the mother when the second child is still in the womb. How does that father get primary caregiving? Can't be done. So for the rest of that man's useful life, he is going to be indentured to the custodial parent, which is a creature of state statute. They've created these entities.
The laws have given the power to women to make conception reality for them in either way, or abortion for them either way, and now custody for them either way. So there's no power for a man in a family, in the state, from the state's perspective.
They are eroding.
Where do you go inside the state to have that protected?
The man is on the outside. They even call it visitation. Now, how in the world are we visiting? We're not visiting I'm not visiting my child.
That's criminal.
Okay? It is. It is an absolute aberration. This is the stuff we employ for my criminal clients in prisons. You know, we're going to have custody. We're going to take you because you committed a crime. We're going to put you in the custody of the state. And then you can engage in visitation processes. Another area that I brought out is, where else do we hear visitation a lot?
Access.
Funerals. Funerals.
Yeah.
They are killing. They are literally pronouncing the RIP to fatherhood in America.
In New York, it's taken us 10 years to get the word access changed from visitation. And this gives you an example.
And even then, Chris, it is nothing more than window dressing. Because the way I'm approaching this is from a functional standpoint. I'm not approaching it from the nice propaganda that they utilize. When they say best interest of the child, they're talking about the best interest of the lawyer. When they talk about, you know, looking out for your children's interest, they're looking out for a multi-billion-dollar industry. And they've just brought everybody into this equation, everybody taking a piece of your fundamental right, and they're torturing it. And so when folks go into court, they have to train themselves. And this is where I get into a little bit about self-representation.
Before you get into self-representation, doesn't the federal government want the states to handle these matters? These are state issue laws. You're going to try and now take this state issue and move it. You have to try to explain to me what you're going to do, all right? Because it is a little confusing for us, because I'm always dealing with the state issue. Sure.
The federal government has become increasingly involved, as we all know. Title 4D, Social Security Act. The federal government has, through lots of influences, incentive grants, manipulated the states essentially to create a uniform parenting environment. We are no longer the laboratories of states where you could cross the border and find a different kind of a philosophy. We move around in the country because we figure, well, if we go to Wyoming, it'll be different there. Federal government has done it. They said, wait a minute, we don't care about the states anymore. It's essentially what they're saying. We want you all to act the same. We're going to give you incentive grants. You'll go broke if we don't give you these grants. Other states will make out better and can compete better with you. And so they create a uniform set of laws. Because the federal government has done this.
Sounds like an opportunity.
And the states, therefore, are no longer states. They have lost their sovereignty. They have waived and given up, abdicated what were reserved powers. As a result, they lose their immunity under the 11th Amendment. They become wards of the federal government, no different than Indian tribes, something I'm very familiar with through some of the casino constitutional lawsuits that I was successful with. And as a result, what we have to then do is attack the issue from the federal government's standpoint. And that's why these issues belong in federal court now. No longer in state court, because we don't have to worry about. These are no longer local matters. When you're affecting the productivity of the nation, the healthcare institutions that are burdened by all the folks coming out of these family courts with all kinds of pressing issues, we have a monumental problem.
Sure, and the speed at which people traverse state lines in every way, vacation in 7 different states in a day. I mean, there's all kinds of reasons why that makes sense to me. So I look at this as a great opportunity, and this is the first I'm hearing about it. I'm doing this for 11 years. So I'm very happy that you're doing this kind of thing. I hope you're successful with it. The test cases, is there anything you can tell us about any of the test cases that have, valid to us in families in transition?
Sure. I have a number of them out there, but the ones that I'm currently doing are in my own right, and some of them have sealed records, so the documents will not be immediately accessible. However, and I think the federal court's doing the right thing. I have to admire what the federal court at least is doing here in my case, because they've understood that parenting is a private matter. It doesn't belong in these public courtrooms. The state, on the other hand, is saying, well, no, this is public interest. Now, let me ask you something, Chris. Does anybody around you really care two hoots what's happening with you and your children? Isn't that a private affair? Hasn't it always been that way?
Sure, and if something went wrong with my family, it would be up to me to fix it.
Sure, and we give you that right in the first instance. If it spills off in the streets and crimes are occurring, that's when it becomes a public interest.
Sure.
But no family is perfect. And those who come into family courts and try to tell us what our problems are and how they're going to correct them, some of these people have never had children, they don't know how to correct them, and they have nightmare personal family problems themselves.
Absolutely, yeah.
So how are they going to give us the utopian philosophy? They can't. Inherently, it wasn't intended that way. Government is way overbearing in terms of the power they've seized. They've done it for money purposes. And as a result, it comes back down to families protecting themselves, parents recognizing that this is a private matter. So one test case is an interesting one. I'll try to do this quickly. It's a case I completed a couple years back. And involved a gentleman who was 3 o'clock in the morning, police came, banged on the door, 3 officers took him out essentially in his underwear while he was sleeping and threw him out of the house on an ex parte, which means one-sided protection order, an application by the ex-wife. And he was accused of everything. Everything from animal cruelty to rape to battered woman syndrome, which is a completely abused a syndrome that does not even exist. But they used the whole scheme of weaponry, typically as part of these custody tactics, and sent him out to pasture. And they hit him with child support orders, and he couldn't see his children, his child, for almost a year. They offered supervised visitation. He was not a good candidate for that.
That's a crime by itself.
No, it really is. And they put him through therapy sessions, anger management. Let me tell you something. If you take a child away from a mom or dad, you better expect there's going to be some anger management.
There's going to be some problems.
Because the person would be abnormal if they didn't have anger issues.
Absolutely true.
You're not going to correct them through any kind of therapy. You need to correct the system first. But in any event, after I filed a constitutional challenge, and it was heard, and it was a 47-page opinion came out of this one, which I was quite impressed, that a family court judge was able to put a very well-reasoned opinion together, but recognized that it had limited jurisdiction. Hence the reason why I'm in federal court. But what's interesting that did come out of it is the family court did say this. We were able to conclusion of that hearing to work out a stipulation. And the father was able to get roughly half time with his child. No more supervised visitation, anger sessions that he failed them all. What struck me as interesting about that case, it's a matter of record now, okay, is that without a hearing, with all those allegations swirling over him, all sworn under oath, in a span of half an hour, a bunch of lawyers got together, the judge issued a ruling, no trial, no hearing, boom, and suddenly he got unsupervised visitation, roughly half the time with his child. Now, what does that tell you?
It's an awful lot of waste.
Well, it tells you what a shame and what a pretext.
That sounds like a mediation, by the way.
Shows you the futility of the whole custodial process, the whole custodial of institution of child rearing. It's collapsing on its own way.
Who can you tell us about in the remaining 6 minutes or so we have left about who the parties are in the suit? and in your suit. And also you make a reference in your notes you gave to me about the custodial parent as a part of the suit. I'd like to hear a little bit more about that.
Sure, Chris. Necessarily, and this all dovetails with everything I've said so far, because the state has decided to seize power it does not have and become super parents over all of the people, which are now the mainstream parenting population, forcing parents to fight over these custodial power and money awards. The state has then dictated that through its judicial branch of government will now be the super parent over children and will decide issues and issue all the orders and everything to regulate parents to the extreme. As a result of that seizure of power to the excess, I've had to name the court system as a whole. We all, perhaps you're familiar, perhaps you're not, but the unified court system of the state sued the other two branches of government for pay raises. You may be familiar with that. The two branches of government said, and they sued them in their own courts, they were clearly violating the separation of powers. They were exceeding their authority, unquestionably, for pay raises from $135,000 and up. And we could get more into that, but I won't here. In any event, the two branches of government, executive and legislative branch, said, we're not going to honor your rulings. In essence, the majority of our government said to the judicial minority branch, we're going to disregard your ruling. That set a very dangerous precedent because it invited the rest of us to say that if our Bill of Rights are being violated in the same fashion, should we disregard these rulings? Now we get into tyranny and anarchy and other issues that we don't need to address, but it does say this much about the whole issue. We do need these things resolved in a court, but not a state court.
Yeah.
So that's why I've named various judges in the unified court system itself. Sued them in another court, the federal government, which is supposed to look out for the protector of our Constitution. And I've named it custodial parent because the custodial parent is the state creature of state law, created this parent and gave them all these different powers and told them how to behave, both as a mother and a father figure, which were traditionally separate individuals. And the parent, the natural parenting figure, was lost. So the custodial parent is no longer as a mother or a father, as I see it. The custodial parent is a creature of state government, which has come in as its agent and made it almost impossible to raise the children in this day and age.
Yeah, I want to thank you very much for all the information you've given us so far. We're coming close to the end of the program. That was a quick 5 minutes. Real quick, you have a conference coming up, Parental Rights, on April 15th, April 17th. You got about 15 seconds to tell me a little bit about that? National
Parenting Rights Convention, the first of its kind. I've patterned it off of the National Women's Rights Convention in the same neck of the woods up around Syracuse, upstate New York, 15th through 17th of April. I'm encouraging all to participate, delegates, advocates, those who believe that the state is too much involved in our parenting functions. And we are going to set a plan of action for a rally in Washington, D.C. so that we can be heard to take back our children.
Thank you very much, Leon Kozel. Thank you very much. Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. Has a lot to do with what he just said, doesn't it? At FIT, we know you cannot get this information on your own, so we'll bring it to your TV, of course, every single week. We always invite all opposing views. My name is Chris DiMaggio. Thank you for watching FIT TV, and we'll see you again next week.